I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this lesson on New England state courts. This lesson is the second in our series on state courts, so if you haven't already, please view the introductory class for your respective state before moving on to this lesson. All classes can be found in our FOI guide at NEFAC.org, as well as on our YouTube channel, 5 Freedoms. In addition to state courts, we also offer lessons on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. SBJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you for joining us for this webinar, which is brought to you by the New England First Amendment Coalition. This session is going to focus on the courts in Maine, and with us is Ali Garmy-Chardon and Christine Hanley, and they're attorneys at Garmy Law in Portland, and they're going to explain in greater detail how the courts work in the Pine Tree State. Ali and Christine, thanks so much for being here.
Thank you, Emily. It's our pleasure to be here. As we said in the last session, we want to thank all of you, members of NEFAC and journalists, for the work that you do. It couldn't be more important, especially right now. So thank you. This will be a short presentation. We are available to answer questions. Hopefully we'll be able to answer them. And if we're not, you'll see at the end, we share our email addresses and contacts. So please always feel free to follow up. And if we don't have the answer today, we'll get it for you. The topics we'll cover today are rules and procedures for accessing records, so written documents, and then we'll go to rules and procedures for accessing hearings in terms of attending them. Then the question of covering hearings, bringing in electronic recording devices and how to do that. We're going to touch on what to do if your requests are rejected in terms of appeals. We won't have time to get into the exact nitty-gritty of all of that, but we will touch on what to do and how to object to as well or appeal rejections of FOA requests, which is related to the issues of accessing court documents.
So I'll start by talking about rules regarding access to records. So there's a judicial branch administrative order that covers at least what the courts define to be public information versus confidential information. The judicial branch, in theory, starts from a policy of providing access to everything, but then it says except for all the things that they don't provide access to. So this administrative order, JBO 520, which I think we can provide a link to, if it's not a clickable link in the materials, is a good starting place because it does reference all the other statutes and rules and other places that you'll see what's confidential and what's not. But I'll give you a brief overview of what actually is confidential. As I said, the default should be information that is public. But confidential information has its own court or statutory confidential court information has a court definition in the order. And then confidential criminal history information is defined by statute. In Maine, we call it CRIA, or you'll hear CHRIA. It's the Criminal History Record Information Act. Which is about as clear as mud and leads to some really odd outcomes in terms of what ends up being public and what ends up not being public. But it's contained in that statute. A great case, though, that explains it's Maine Today Media, Inc., and that one was litigated by Sig Schultz, who I think is either a board member or some prominent member of NEFAC. And even if, I guess the takeaway is, even if it fits under one of these 19 categories that are exempt from disclosure, that doesn't mean it's just a hard stop. It means that the agency has to explain why they shouldn't turn over the information. So if you're doing a FOA request and you just get, no, it's confidential, that's not a good enough answer. They have to say, no, it's confidential, and here's the problem with why we can't turn it over. Long story short, you can solve a lot of things by asking the court to get involved, and the court can issue a court order or a protective order to basically balance the interest of why the agency is trying to keep it private versus the interest of the public and the press. In the TRIA setting, you'll get a lot of, they'll say, oh, well, it's an ongoing investigation, we can't turn that over. And in that Maine Today Media case, the court basically said that's not a good enough explanation, because then nothing would ever be public about any criminal investigation. So you have to actually specify what the reason is. And that's the same rationale for all the other exceptions too. The agency that's holding the record has to actually explain. They have the burden of saying it's under an exception that says we shouldn't disclose it, and here's the problem with why we can't disclose it. How to access court records. There are a number of records that you're not going to have problems accessing. Maine right now has a bifurcated system, and we talked about this a little bit last time, that we have a couple jurisdictions that have e-filing. And so I have the links over here about how to get access to that. A couple, and then there's traffic. Traffic's probably not going to be something you're terribly interested in, but they have electronic records. And then everywhere else is still on site, where you can basically, in theory, anything that's attached to a public hearing the documents should also be public, but you have to figure out which court you're going to be in. And that's where the training from last week or last month at this point would be helpful.
And just to be clear, on site, it's not on website. It
Right.
is physically going to first calling the clerk, making friends, showing up, and making photocopies, paying for photocopies. We'll talk about that, but the first and the primary way to do it is to request a photocopy. We'll come back. Do not simply take a photograph of a document. I'll touch on that in a few slides.
Yeah. I've gotten in trouble for that myself when I thought that I was being quick. And ironically, it was a file that I was involved with, so it shouldn't have mattered anyway. But yeah, don't do that. Don't just take photos. And then the main rules of the electronic court systems. I think I said this last time, they default to public access, but then it's basically except for all the reasons why, all the balancing interests. And so one of the things that if you're all getting pushback is really just how you frame your interest. And I have a slide on that in a little bit.
And I want to interject. We did reach out to the administrative office of the courts, in particular the access coordinator, who deals largely with issues of like disability access or interpreters and things, but does actually, her name is Allison Gray. She's a resource. She's findable through the administrative office of the courts. And the other person is the director of legal affairs, Barbara Cardoni. She is really the primary contact if you have questions about accessing records or hearings, and she, I think, will make herself available to answer questions if you have them. Yeah. And in fact, we spoke to her in advance of this, and she volunteered that as well, that people can contact her and she can then coordinate directly with the administrative office of the courts. But she wanted us to she wanted to note that as Maine transitions from paper to electronic records, there will be, in my words, growing pains. And that they are doing their best. This quote is from her. They're committed to keeping the public informed of their policies and procedures. You should expect, though, that these will develop and change, and that this part of the PowerPoint will hopefully be outdated quickly, because we will be able to have more courts come online, more jurisdictions come online with online access.
So for things that aren't online, here are some forms about how. So basically the old school way is you can either go to the clerk in the court if you actually know what you're looking for. You can also do a written request for a record search on an individual person if you know the person you're looking for. And that goes through the court's central office. And so it takes time. If you actually know where you're looking, in theory, you should be able to go and get access on site. But bear in mind, courthouses like Portland and York County have a lot larger staff and are probably a lot more capable of dealing with requests on the fly. Some of our smaller courthouses literally have 1 or 2 clerks. So the sooner and earlier, as Ali said, you can call, make friends, let them know you're coming. Even if they can't officially pull the file for you with a phone call, they will set it aside and know you're coming, and will at least make, if they know you're coming, they appreciate that, and they'll make your life easier when you get there. There's also a form for requesting transcripts. Maine has a thing where most things are also recorded because we're doing almost everything without live court reporters now, except for full-on trials, but almost all the other proceedings are just audio recorded and then later transcribed if needed. So in this court transcripts form, you can also just pay $25 and get the audio of the hearing. It's much faster than transcript. It's cheaper. And if you're trying to just clarify what was said or what type of information you're trying to report on, the audio can be a quicker, cheaper, easier method to go. But it's on the same court transcripts form.
Did you answer, how quickly does that normally come out?
I've gotten them in a day or two.
So that's really interesting. So that's actually important to note, that it's a workaround if you don't have time to request recording privileges. Although you can't get your story out same day, you'll be able to get access to these within a day or two.
Yep. And the woman who runs the audio side of the judicial branch from the clerks section is a Spitfire, and a lot of times she can get it done right away, but she just asks me to not promise that. Just because she can doesn't mean she always can. But she's another good person to be friends with. So if anyone ever has questions on that front, let me know and I'll link you all up. And then another way to do it is if you're looking for a criminal record, this is the link through the Maine State Bureau of Identification. That has limited, based on Sharia's odd definitions of what is public and what's not public. It's kind of a hodgepodge of what information you'll get. Sometimes you'll see that someone was charged and you won't see the disposition, which means it was probably dismissed more than a year before you're looking for the record. But if there was a conviction, you'll see it on the Maine State Bureau of Identification. So just flagging that you may think it's an like an open thing or an unanswered charge, and it might mean that it's been disposed of, but ironically the favorable disposition is private, but the charge was public. So I will turn it over to Ali to talk about actual court hearings.
This slide, confession is a copy paste from our last presentation, but we thought it would be a helpful refresher. Although I did put the red font, which I think was a great addition. Certain court hearings are private, they're not public by default, and you will have a very difficult time. In fact, you won't be able to get access to those. So that's juvenile proceedings, except for felonies and bindovers. If you have questions about that, contact Christine Hanley, my criminal law expert. Mental health commitments, treatment court, grand jury, everything on that list, what you might expect. Everything else should by default be public, meaning that you and any other citizen should have the right to, any other person should have the right to access it. These are just some of the basic principles underlying or sort of the announcements of the basic principles and where to go for references if you were to need an argument for why you should be allowed public access. And that includes Supreme Court decisions and our Supreme Court decisions. We have First Amendment right of access to criminal trials. The Sixth Amendment confers the right on the defendant to public access. However, our law court has held that having a public trial can protect against possible abuses of judicial power, lead to more truthful testimony, and may generate publicity that could cause witnesses to come forward. So in State versus Pullen, you can see some of that articulation of all the positive reasons why you should allow access. And there is a default under the state statutes that criminal proceedings are public unless there's a substantial likelihood of damage to the right to a fair trial, and there's no good alternative that could protect the right. So, and I was dealing with criminal hearings in the prior slide, and I apologize for the number of mismatched colons in this. All these journalists are cringing on the grammatical error. But in civil cases, there isn't actually a constitutional right to open courts, but there is a default presumption, and that will be you will see that honored in in every case unless there is a special exception. We have a rule of civil procedure that that expressly states that trials shall be in open court. And we have another one that says that witness testimony should be in open court. And so because of that, closing a court proceeding would require a similar finding as other First Amendment protections. And so it is necessary to serve a government interest, and there's really no good alternative. Notably, as we'll cover at the very end, I had forgotten that FOA or FOIA also covers right of access to public hearings. And so that should also be remembered, that it could potentially provide a second, a good second argument. I would hope you wouldn't need it, but that any public proceeding would be available to the public under FOA. So that was, when we're talking about access, that's attending hearings. And it's important to remember that when we talk about attending or even recording hearings, that's what I mean by covering hearings, the press has the same standing as any other person who wishes to do that. And so, I think on the one hand, what that means is that you don't need any special affiliation or accreditation. In fact, the Barbara Cardoni wanted us to make sure to convey that there is no special treatment for media, but it is the same public interest that applies to all persons, all citizens, applies to the media. So if you want to record a hearing, whether on audio, photograph, or video, you do need permission. It's covered by an administrative order. I don't know that you'll have access to these, what we put links in here, but I don't know if you've got access to that. That's fine. You can Google it. It comes right up. In order to avoid the default rule of no electronic devices in the courtroom, and by the way, that rule applies to cell phones, even for attorneys. And so if you're watching court, you should be careful not to have electronics out, because the judge and the bailiff will not be happy with you.
Can I interject on that?
Yeah.
Some courtrooms and judges are stricter, some are less strict. It's always good to just use the form to ask for permission to have your electronic device. Don't even try to record without asking for permission. But if you're just using your phone, like for email while you sit there to take notes, or you have a laptop, it's always really good practice to flag the marshal in the courtroom that you're in. Tell them who you are, tell them you have a phone or a laptop and you want to use it, and see, and basically ask them if the judge is going to be okay with it. And that's basically what we have as attorneys have to do as well. Like I said, there's some judges that are like, yeah, it's fine, we get it, you're a professional. But there are others where you'll get a bailiff barking at you to put your phone away. So always good to get there a few minutes early and just ask, and they'll tell you. You'll find out right away which courtroom you're in.
And so I would always start, if you want to cover a hearing, please start with reading the administrative order, because it's actually pretty detailed, and it has standards that you would want to be aware of in terms of if you are going to be allowed to do it, what those standards are, right down to you must be professionally attired. You cannot have you cannot have recognizable marks of an affiliation with a media. Any kind of media. I do. I guess I put it backwards, because I did want to say, I think, there we go. Well, we'll put it, I put on red, never coverage of a jury before adjournment. So recording the jury. is never okay with or without the juror's consent. And you may not record in any way or really listen into sidebar or chambers conversations. Other items listed under the standards of conduct in the administrative order are things like neat attire, no distracting sounds, no indication of organizational affiliation. Where you're located is subject to court approval. So a great idea, if you do have permission to record anything, I would absolutely check in with the bailiff or the marshal prior to doing so, to let them know what you're doing, what your permission has been. I'm sure they're probably going to be aware, and they may have thoughts about where you need to be. No artificial lighting. Read all of them. There's probably some that you would find more important than not being a journalist, I wouldn't even understand. Here's how you do it. There's a form available online at that website that I've pasted there. It's media coverage request form, and they ask just 24 hours in advance to submit that. Note that if you wish to photograph court records, you need to use this form. So that means that if, we talked earlier about access to documents and how you would request copying. If you're not going to request copying, but you're going to take a picture, even if you're taking a picture of a court record in a courtroom, you're going to need, obviously, any pictures in a courtroom, you're going to need permission. Also, please, you should be aware that it covers photography and recordings outside the courtroom, but within the courthouse. So if you want permission to make a recording or an interview with a witness or an attorney or anybody like that within the courthouse, you do need permission. And again, that would be Barbara Cardoni, who is the Director of Legal Affairs and Public Relations. Of course, you can always go outside to record. If you were to be denied of right to access or cover, in terms of access, you should look back at that Maine Today media decision that was brought by Sig Schultz, your attorney, NEFAC's attorney, that decision again emphasizes the importance of keeping these things public, including voir dire proceedings. So in that case, the court announced that, just a general worry that jurors might be less open to being honest in front of the media or the public is not enough to mount the hurdle that you would need to prove that something should be private. So that's a very helpful decision. Under the administrative order, however, decisions regarding coverage of proceedings, recording, are not reviewable. So I frankly, if that were to come up, I think it might be novel, and it would be, I would escalate that question up to Sig Schultz most likely. But the order does state expressly that, it's the trial judge's discretion, and what the trial judge says goes.
Next one's me.
Yeah, go ahead.
So all the more reason when you're articulating your request, be respectful. I know you all are anyway, but being respectful to the clerks and the bailiffs, and basically paving your way where it's like, yeah, we want to help this person, so that when the order gets in front of the judge to sign or not sign, it's kind of already something that they either do or don't want to do. Getting it, if you can do the 24 hours in advance, the court's going to be much happier to basically have been acknowledged that you gave them plenty of opportunity and warning, and you kind of making it their opportunity to say yes. If you rush them or try to use importance to do it, you might get a cantankerous judge that says, nope, go away. And as Ali said earlier, the court does not view any particular special privileges to journalists versus other members of the public. But there's this great language that was cited in a different Maine media, and I need to change that site, I'm sorry, but a different Maine Media Today case, same year, Sig Schultz was handling that one too. And I'm going to touch on that for a minute just because I happen to have some other information about it. But basically media, although the media and the public are treated as the same, the purpose for having the media access It's basically you're representing the public. So if you can couch it in the fact of we are representing the broader public, and the purpose is shining a light on democracy. So this quote, I'm going to read it just because it's, it goes right back to the founding of our country and First Amendment. But the generation that made the nation thought secrecy in government one of the instruments of old world tyranny and committed itself to the principle that democracy cannot function unless the people are permitted to know what their government is up to. And so the note that I would put on that is it's not, the public interest is not in the specific story necessarily, even though that's why you're there and that's what you find fascinating. I think the more it can be framed as the public interest is in what the government is doing and how they're handling these proceedings and how they're handling court in general, might get you further in terms of the justification for what you're doing, even though it may be just a particularly good story that you're interested in. And going back to that though, so that case, that was a case where Maine Today Media was seeking access to the 911 tapes in a homicide case. And the person had already been charged, the case was pending, and the police department and the AG's office, they all cited TRIA, right? It's kind of, I don't know if agencies are actually afraid of it or if they use it as a shield, but basically they just said, nope, it's all covered by TRIA, we're not giving you anything. The Maine Today Media argued that they had a right to have access to that information. And so even though the 911 tapes are in one of those exceptions of what's, criminal history information under one of those 19 exceptions somewhere, the court held that a general interest in protecting an ongoing investigation is not enough. The state has to do more than that. And they really couldn't come up with a good reason why a 911 tape harmed anything in an ongoing case where the person had already been charged. It's not like there was wiretaps or turning over witnesses that we didn't know about. I mean, it was a very public case. It involved a homicide where the landlord shot and killed 2 kids in the apartment next to them and shot and wounded the mom of one of the kids. And then I ended up involved in this case later. The weird thing about TRIA is even the victim in that case had to get a court order to get the discovery. So even though she was the victim, she had been shot, and it was her kid who had been murdered in the homicide case that was pending, the state gave her very limited access to the information in the case while the case was pending. And then even when the case was over, they basically just cited TRIA. And so she had to go to court and get another court order to basically get access about a case that had to do with her. And the court again said, this is bananas, basically. There's no valid reason for her to not have access to this. And then they just issued a protective order, which is basically like redact all the information that has nothing to do with this victim. And that's what gives the agency cover to turn everything over. So the reason I went on that long aside is a lot of challenges and ills about trying to get a record can be solved by asking a court for protective order, because if the state has to cite what concern they have, and a lot of times those concerns can be protected in a less broad way than just not turning over the records.
That's fascinating. And I'm curious, we were mentioning last episode in the last session that sometimes we've benefited from journalists kind of cracking open cases for us. In this case, it's because Christine represents still to this day some of the victims of that shooting. Did the 911 tapes that got released following this decision help you in investigating your case?
It was the WatchGuard video that was released in the second court order when we had to get it. But yeah, same principle of, because this order had already come out, it made it much easier for us to argue that, why can't we have and when I say WatchGuard, that's the body mic that the officers had on when they were talking to everyone. So basically same theory applies, right? If the 911 tapes have already been released, why can't the mic? And that was the only reason our case was not time barred was because we hadn't had access to that piece of information yet. And so it was very helpful.
Yeah. Not to say that it's easy to bring these decisions or cheap, but it's amazing when it can be done. FOA, we've actually talked about FOA a little bit, and I think I might be mistaken, but I think one of the main today decisions we talked about earlier actually did have to do with FOA. You know, FOA is a different way to access public documents, and Maine has a lot of information. When we say FOA, we mean it's the same thing as FOIA. It's just Maine's is under, we call it FOA, Freedom of Access Act, I think. And Maine provides a lot of information. So there is a contacts list available for each agency where to direct your request. The agencies have 5 working days after the receipt of the request to either deny it and tell you why, or tell you that they're going to be looking for records and we'll get back to you. We're going to give you something, but we'll get back to you. In terms of how much time they have to actually respond, I think it's they certainly take the approach that it is murky. And I think it is. I think that as long as they give you that answer and then tell you, it's going to take me a long time to do this. And they'll usually often be very specific. I have 45 requests in front of you, and I expect this to take 2 weeks. Frankly, if you were going to challenge that, you might have difficulty, because I think that a court might say that's reasonable. They're doing their best. But ultimately, there is recourse for you. So while they can charge you for copies, they can't charge you for electronic copies, and they can't just they can't ignore you. The
reason I was smirking though is because it is reasonable. It has to be a reasonable time frame that does not negatively impact the function of the agency. And so the standard response you'll usually get within 5 days is we've received your request, and we will try to figure out how much time we have to take without impacting the functioning of our agency. And that's where I think they play with it, because it's not okay that someone has to actually spend time. That's not an impact. I think it's supposed to be that we're not totally, toppling government agency functions by making them run around for records. So basically, long story short, whoever the point person is, just keep basically firing off check-in requests, because the more specific you have to make them about what they're doing and when, the better. Yeah, I agree. And I think I've been through this recently in the past couple of months with a couple different agents, and I took the approach of being very grateful for their time and understanding. Sorry to bother you, but I think it helped. And I think, because as Christine just explained, it's not like you got strong ground to stand on to be fire and brimstone. So kindness kills is maybe the better approach. This is actually kind of redundant towards, I think, another slide. You can object. So they can, by the way, file a motion to protect in the Superior Court, and you can also file an appeal. And that is expedited in a sense, because you can do that within 30 days of their denial. So, and you can get attorney's fees. That does not mean you will be able to find an attorney who can do it, but you can get attorney's fees if you prevail. And a nice reminder that FOA also covers access to public proceedings. I think the legislature is pretty aware of this, and lots is on Zoom and available now. But this is a list, again, on the statutes are online. So is there a very helpful frequently asked questions page that I've linked there. But, if you were to want access to a public proceeding, and you can argue it falls under any of these categories, you should by right have a right to access it. I have actually already touched on the expedited appeals. You may appeal to a decision. So I can just jump in on the appeal piece. If you go back to the first the first talk we did, we have like a breakdown of which court is which. If you're denied, not coverage, because that's different, but if you're denied access to a district court proceeding, that would get appealed to the Superior Court first. If you're denied access to a Superior Court proceeding, you would appeal it directly to Maine's law court. All of the rationale and reasoning has to be the same, but for a few of our trial courts, there is still that intermediary appeal in Superior Court.
So there's a lot of information online, but the administrative orders will really guide you. And you can search for those. They're available. And if there's a blanket policy or practice, you may request what administrative order they're citing. And these are very detailed and you can read them. That should be helpful to you. Local practice or approach to those orders could be different, but those orders should be the guiding light, and you can get to know them. So that takes us to already 40 minutes, longer than we anticipated, but we're available if anybody has questions.
Allie and Christine, thank you so much for taking the time to give us this great overview and go a little bit more in depth about the court system and navigating it in Maine. And thanks for everybody for tuning in.
Thank you so much, Emily.
Thanks for
Take care.